Judgment in the appeals, Goluchowski and Sas against the district courts in Poland.
European Arrest Warrants, EAWs, have been issued for the appellant's extradition to Poland, where they are wanted for the purposes of serving sentences of imprisonment, some of which were only activated after an unsuccessful appeal, or were activated or reactivated after initial suspension or early release, followed by a breach of conditions. The appellant's extradition to Poland was ordered pursuant to these EAWs. The appellants appealed on the grounds that the EAWs are defective under Section 2, subsection 6 of the Extradition Act 2003. This requires that an EAW in a conviction case contains not only particulars of the conviction and of any sentence imposed, but also in paragraph C, particulars of any other warrant issued in the Category 1 territory for the person's arrest in respect of the conviction. Various domestic summonses or warrants were issued in Poland in unsuccessful attempts to find and arrest the appellants there before the EAWs were issued with a view to their surrender or extradition from the United Kingdom. The High Court dismissed the appellant's appeal against the extradition orders and certified as questions in summary: 1, whether an EAW is defective under Section 2, subsection 6, if it omits particulars of domestic warrants issued in the issuing territory to enforce that judgment or order there, and 2, whether Section 2, subsection 6c requires an EAW to particularise not only a conviction, but also every decision whereby the requested person was required to serve an immediate sentence of imprisonment, and following which it could be said that he was now unlawfully at large. The Supreme Court dismisses the appellant's appeals. Lord Mance gives the leading judgment, with which other members of the court agreed. Lord Neuberger concurs shortly. The European Union framework decision, on which the provisions of Section 2 of the Extradition Act 2003 are based, does not explicitly distinguish between accusation and conviction cases, but in practice there are significant differences in the bases on which EAWs in each category of case will rest. In an accusation case, an EAW will normally be based on a domestic arrest warrant, whereas in a conviction case, the natural basis of an EAW will be an enforceable judgment. Where there exists an enforceable judgment, there is no reason why there should necessarily be any domestic warrant, and if there is no obvious reason why it should be required to be evidenced in the EAW. A domestic warrant may be required in a conviction case where a person is at large when convicted, has absconded, and is wanted for sentencing, and might in such circumstances be regarded as constituting the basis of any EAW issued to secure his surrender for sentencing. But where a person has been sentenced to an immediate sentence of imprisonment and is due to be in prison but has absconded, there is no obvious reason why there should be any domestic warrant at all, or why, if there is one, it should be evidenced in any EAW issued to secure the offender's return. The present appeals involve sentences of imprisonment which did not take immediate effect. Only the first and third EAWs issued in relation to Mr. Sass are presently relevant. As regards the conviction, the subject of the first EAW, Mr. Sass was free until he lost his appeal, whereupon he was summoned to report to detention, which he failed to do. A court order later issued to secure his attendance was irrelevant to the enforceability of the sentence and could not constitute a warrant for the purposes of Section 2, subsection 6c, and did not therefore need to be particularised in the EAW. As regards the conviction, the subject of the third EAW, Mr. Sass was given an immediate sentence of imprisonment but granted conditional release. This was revoked when he breached the conditions of his release. When he failed to surrender, a domestic warrant was issued for his arrest. As regards the conviction, the subject of the EAW relating to Mr. Goluchowski, the sentences of imprisonment passed were suspended but were ordered by the court to be served when he broke certain conditions. In these circumstances, Both appellants were due in respect of these EAWs to attend prison without more as a result of court orders, and only when they failed to obey those orders were any domestic court orders, summonses or warrants issued to secure attendance at the relevant correction facility. These further domestic orders, summonses or warrants are therefore irrelevant to the EAWs, did not need mentioning in them, and did not constitute warrants under Section 2, subsection 6C of the 2003 Extradition Act. It was not necessary for the EAWs to contain evidence of the decisions resulting in suspension of Mr Goluchowski's original sentence and its subsequent activation, nor of Mr Sass's conditional release and the subsequent revocation of that release for breach of conditions. On their face, the EAWs give details of judgments which by themselves required the appellants to begin immediate service of a sentence. They do not contain details of every judicial decision by which the sentences became immediately enforceable, but to require such details would firstly mean that an EAW should set out a quite complex history of proceedings, whereas Box B of the prescribed form of EAW contemplates a single reference. 2, run counter to principles of mutual confidence on which the EAW regime is based. And 3, overlook the fact that an executing state can always request more information from the requesting state, as it seems that the UK did in these cases. However, a final decision on the extent of the details required is unnecessary, since the processes by which the judgments became enforceable is clear from the subsequently obtained information, and EU case law establishes that an otherwise valid EAW is not to be treated as invalid or ineffective merely because the full history is not contained in the EAW itself. Even if a reference to the activating decisions should, strictly speaking, have been made in the EAWs, along with the reference to the judgment as enforceable, this cannot mean under European law or the Extradition Act 2003 that the EAWs should be treated as incapable of being executed. The court will adjourn.